Honorable the Vice President.
Senator Hosein. Thank you very much, Mr. Vice President. And Mr. Vice President, before we went to the lunch break, I was on the point with respect to the powers of the DPP and whether or not the section 31 of the bill would in fact be inconsistent with section 90 of the Constitution, whereby the DPP is now being asked to perform a function of a civil nature, whereas under the Constitution, section 90, he is constrained to only criminal matters. And Mr. Vice President, I'll move on from that point because I would have given various sections in which that relates to. But when you look at clause 65 of the bill, and clause 65 is probably one of the clauses in this bill, in particular subsection 4, which goes to the heart of the constitutionality of this bill. And it states that any proceedings under this section, and this section deals with the unexplained wealth order, the burden of proving the wealth of the respondent is the person whom the order is going to be made against, is lawfully acquired, lies on the respondent. So what this section is saying, Mr. Vice President, is that when the agency brings an action against a person, ordinarily in criminal law, or even in civil law, those who allege must prove. But in this case, the person who is alleging doesn't have to prove anything, because by subsection 4, it now requires the person whom the allegation is made against to prove his innocence. And Mr. Vice President, this goes directly to the heart and the jurisprudence of criminal law, because there's a case of DPP against Wilmington, where the golden thread that runs through the criminal justice system is that the accuser or the state must prove their case beyond a reasonable doubt. And Lord Sankey, and Mr. Vice President, you would find that this is one troubling position because there are persons who may not be able to prove their wealth by documents because they have bad record keeping. Mr. Vice President, this legislation is operating retroactively. So therefore, persons would have conducted themselves in a particular manner before the legislation came into force. And Mr. Vice President, it shows that this piece of legislation is directly in contravention with Section 4 and Section 5 of the Constitution, notwithstanding this bill is being brought to this Honorable Senate without the requirement of a special majority. And I looked again at the Mauritius jurisprudence. And there's this case called the DPP against Kohi Ali in 1999, where the Supreme Court had held, Mr. Vice President, that a suspect must be treated as not having committed any offense until the state, through the prosecuting authorities, adduces sufficient evidence to satisfy an independent and impartial tribunal that he is guilty. The presumption of innocence requires that even a court should not start with the preconceived idea that the accused has committed the offense charged. And Mr. Vice President, this subsection 4 is in direct contravention with the jurisprudence coming out here in the Supreme Court of Mauritius. And I use this case because this case was being examined at the time when they were passing their similar legislation, just like this that we have before this Parliament. And they identified these problems within the framework which was given or laid in that Parliament. And Mr. Vice President, it goes on to say that this doctrine that a person who alleges must prove, it protects the accused against improper compulsion by the authorities, thus reducing the risk of miscarriages of justice and embodying the equality of arms principle. The prosecution must prove its case without resort to evidence obtained through coercion or oppression. And here, this, Mr. Vice President, which is probably one of the most important pieces of this. It says, security and public order cannot justify the suppression of these rights. The cases Heaney and McGuinness against Ireland in 2000, Mr. Vice President, a case coming out from the ECHR. And Mr. Vice President, this goes to the heart of this bill. The government is justifying a reversal of the burden on the aims of security and public order. Exactly. The Attorney General relied on the European case, and Senator Ramdeen will deal with that. And Senator, so therefore, Mr. Vice President, you see that the jurisprudence the Attorney General is quoting from is very selective, because you have this case saying it plain that you cannot limit these rights based on just security and public order. And yet this bill is not being cloaked with the protection of a special majority from Parliament. And that is a very important point, Mr. Vice President. And if you look also at what the paper said, this is what the paper said. It says, by shifting the burden of proof on a suspect, this is Mauritius saying this, almost identical to what we have. The bill is aiming at destroying the whole fabric of the rule of law. That is the hallmark of our democracy. And when you look at our Constitution, the first section, in fact, that is section 1 of our Constitution, it says, the Republic of Trinidad and Tobago shall be a sovereign democratic state. And what does this mean, Mr. Vice President? There are several cases coming from the Privy Council that dealt with that first section. One of those cases was the case against the state against Koirati. And Mr. Vice President, by the mere fact of stating that Trinidad and Tobago is a democratic state, the principle or the doctrine of the separation of powers is implied within the Constitution. When you read the Constitution, you will see that the executive, the judiciary, and the parliament are all placed in different sections. Those imply the mere fact that our Constitution provides for the separation of powers. When you look at the bill, what it is proposing to do, you are allowing the administrative arm of the state, the executive, to interfere with some of your constitutional rights, Mr. Vice President. And that bill, and I don't know if Senator Ramdeen, he will deal with those aspects in terms of the separation of powers and the constitutionality of the bill. So there are three factors that I had alluded to. The first is that the legislation is retroactive. Second, it's against the rule of law. Third, there are issues with regards to the separation of powers. The fourth, there's a shifting of the burden in this matter. And yet again, we have advised the government. We have given them the support in the other place. Senator Mark has signaled that we are giving them the support in this place. Then what is the difficulty with putting the preamble for the requirement of a special majority? There is none. The opposition has understood what the aim of the government is, and we have lent the support to the government. So I think the government should at least be cooperative in order to protect themselves and the taxpayers. Because, Mr. Vice President, if this legislation is challenged, if persons' properties are seized based on an unconstitutional law, it's not the government that is going to be paying that money, Mr. Vice President. It is the taxpayers of this country. And these claims will be not $500 claims, not $1,000 claims. These will be multi-million-dollar claims that the taxpayers of this country will have to satisfy. And this, thank you. And Mr. Vice President, when you look at Clause 7 of the bill, Clause 7 of the bill deals with recoverable property. And it states what is not recoverable property. And recoverable property will be those what are criminal properties. Now, because we have scheduled over in the other place that criminal conduct will constitute terrorism, including terrorist financing, I think there's a duplication with respect to the definition of what will be criminal property, because criminal property and terrorist property are both stated differently with respect to the bill, Mr. Vice President. And I think terrorist property will now, or it should properly be defined as criminal property, because there's no reason for a distinction. Yeah, they'll intersect with each other. Now, Mr. Vice President, when you look at what is recoverable property and what ceases to be recoverable property, one of the loopholes we believe that a person may be able to get out of this piece of legislation is that property ceases to become recoverable property if, pursuant to a judgment in civil proceedings, the defendant makes payment to the claimant or the claimant otherwise obtains property from the defendant. And if civil proceedings have commenced and the property obtained by the claimant would be recoverable property, it will cease to become recoverable property. Now, Mr. Vice President, if myself and Senator Bean, let's assume that I have criminal property that is recoverable. All I have to do, Mr. Vice President, is tell Senator Amin to sue me. And then I admit the judgment. So she has judgment against me for the property. And then the property ceases to become recoverable property. So, Mr. Vice President, it shows that there are loopholes in which that needs to be plugged within this legislation, because this can be used by the criminal elements in order to get out of these provisions that the Parliament is providing for. And that is just one example of the loopholes. But we are glad on this side that the government has decided to bring this bill. We are happy that the decision is now. It is 1 year before a general election, Mr. Vice President. And within the last decade, or the last 5 years, within the PNM term of office, there has been one of the greatest scandals in this country, Mr. Vice President. And Mr. Vice President, when you look at the scheduled offenses at number 9, that is fraud. Fraud. And Mr. Vice President, when you listen to revelations by the leader of the opposition a couple of years ago, that the taxpayers of this country lost over $100 million in fake oil, we expect that this legislation, this piece of legislation, will follow that money, that it will follow the $100 million in fake oil. And when you look again, Mr. Vice President, you see drugs and trafficking, another offense. We know, Mr. Vice President, it's news that millions of dollars worth of drugs were found in Westmoreland. And we hope that this piece of legislation will also follow that money.
Yeah.
And there is so much money again to be followed, Mr. Vice President, that when this legislation is passed, we hope that it is proclaimed in the same speed in which the government wants to pass it, so that they will have to be accountable for what they have done in their term of office. I thank you very much.
Senator Dillon-Remy.
Mr. Vice President, I thank you for allowing me to join this debate on an act to provide for the establishment of the Civil Asset Recovery and Management Agency for the recovery of criminal property through the use of the remedies of restrictions in dealings with civil assets, restrictions and forfeiture of criminal property and the management of criminal property and unexplained wealth orders and matters incidental thereto. Mr. Vice President, permit me to indicate to the Attorney General that for my non-legal mind, it was a bit difficult to go through 76 clauses and 3 schedules with a bill that was received on Friday the 12th to debate this morning, a mere 72 hours to do our research. Attorney General, it would have been good for people like me who have to go through all this legal jargon, shall I say, in order to be able to meaningfully contribute to this bill. Permit me, Mr. Vice President, also to make some general comments about my concerns as to where we as a nation find ourselves today. For all these laws we are passing, and I hear the Attorney General's passion, and I know that the desire is to see things go in a different way in Trinidad and Tobago. But my concern is that where we are at as a nation, we would need a transformation at every level in this society in order to see any meaningful changes occurring, and not just by passing laws. For instance, Mr. Vice President, at the political level, we need meaningful changes. We need values that says that what we agree to in government and what we consider appropriate in government will not become suddenly bad when we're in opposition, and vice versa. Our values have to remain true to our commitment to our nation. At the judicial level, we should also have those same values that would result in when we, as the judiciary, dispense justice, our people must have the understanding and be confident that they are being treated equitably. In the business sector, the values must certainly be ethical and legal, because as Senator Mark already so clearly explained, the crimes are not just in the society, in the lower elements of our society, with the boys on the blocks wearing bling. The crimes also occur at the high levels, and we need to conduct ourselves differently at that level. Similarly, in the law enforcement and at every level, including our homes, where our people are nurtured, either for the good of the society or the ones who are the homes that are nurturing criminals. We also need those values expressed at the level of our faith-based organizations. The values we consider important have to be conducted and practiced in our churches or mosques and in our temples. Mr. Vice President, I humbly put this forward, since at every level we are blaming, everybody's blaming everybody else. When a government is in office, they blame the opposition. When the opposition is in the opposition, they blame the government. And we've had enough of that. I'm suggesting that we need to conduct ourselves at a different level. The white collar, the people in business are blaming the blingers. The blamers are blaming the people in office. If we as a nation agree that I'm suggesting that if we as a nation agree that we need to operate in a different level, it has to happen at every level of the society, Mr. Vice President. Many of the points that I had to make were already cleared up by the Attorney General in his presentation and Senator Vieira in his. But I would just like to make a few more comments. Under Clause 14, subsection 2, page 13, the establishment of the Civil Assets Recovery Management and Unexplained Wealth Agency. Mr. Vice President, this agency has wide powers. And even though the provision is there for the appointment of the people by the President or by the President in consultation with the Prime Minister and the opposition leader, or with the Judicial and Legal Service, I'm just suggesting that these wide powers, we have to just ensure that there's no abuse of this power, while at the same time ensuring that they can be efficient in terms of their carrying out their mandate. The clause 21, 2D on page 20, the financial provisions for the agency. The agency is allowed to borrow money to meet its obligation. I am not sure that an agency that is responsible for removing, taking possessions of, and preserving, storing and managing criminal property, terrorist property, or instrumentality, I'm not sure the powers they are given to borrow money as to why is that considered important. It is not the remit of other corporate bodies, for instance, the regional health authorities, where in many cases they do not have what is necessary to carry out the mandate on a day-to-day basis to provide health care, and they are not given the powers to borrow money. I don't know whether the Attorney General would like to comment on that. And finally, Mr. Vice President, in Part 4, Civil asset recovery. Clause 35(2) says, before varying or setting aside the property restriction order, the High Court shall give a person who may be affected by its decision an opportunity to be heard. Mr. Vice President, this is happening at a time that may be very far from when the proceedings would have been initiated, and this is the first time that that person is having an opportunity to question or be heard as to the rights or not of their property being seized. I just think, again, that we should ensure that there's some fairness in the process for the person who may not be as yet convicted of a crime. And I also agree with Senator Vieri when he talked about paying the compensation to the person who has their property seized, that they should not have to go to another court proceeding to receive compensation, but that it should happen a bit closer to the event. And with those few comments, Mr. Vice President, I thank you.
Senator Teemal.
Thank you, Mr. Vice President, for the opportunity to contribute on this bill. With your permission, I'll use this short title, Civil Asset Recovery and Management and Unexplained Wealth Act 2019. Mr. Vice President, the Honorable Attorney General, in his contribution, did spend a lot of time explaining the purport of this particular piece of legislation, the thinking behind it, and the issues and challenges that hopefully this piece of legislation would help the country to address and to start solving. I would like to just go directly into the bill itself, Mr. Vice President, and in clause 3, on page 2 of the bill, where there is a definition of cash, which was also used in the bill that we passed recently, the non-profit organization bill. Just to point out that within the definitions, there's no specific reference to virtual currency or cryptocurrency. And maybe to some extent that is understandable, because to what extent this medium, virtual currency or cryptocurrency, is used by criminals and money launderers. Sorry?
It's under the definition of property. Cryptocurrency is caught there.
Okay, thank you. Other speakers would have referred to the indefinite retroactivity of this piece of legislation, as mentioned in Clause 4, Mr. Vice President. And taking it into consideration, the comments, it's just that I don't think there could be an absolute safeguard, but it's just the possibility that without being given a statute of limitation, there is that potential for mischief and retributive vendettas under this particular clause. We move to Part 2 of this proposed legislation. And under Clause 9b on page 10, it is mentioned that if there is temporary absence or incapability of the trustees to perform their duties, then Clause 9. Then the Judicial and Legal Services Commission shall appoint a person. This was Clause 9.6. Mr. Vice President, I just like to mention here is that the appointment of the trustee is really through the office of the president. And if the trustee is temporarily absent or incapable of performing duties, then rather than just directly by the Judicial and Legal Services Commission appointing a person, I am humbly submitting that should be done with the consent of the president. Clause 10.4 on page 11. As to the salaries of the trustees, it is stated there it should be a charge on the consolidated fund. And the query is that seeing that there's a civil asset recovery and management fund that is allowed for in this particular piece of legislation, the question is why not the salaries and expenses of trustees should not be paid out of the Civil Asset Recovery and Management Fund, which covers monies for the agency, rather than it being a charge on the consolidated fund. Clause 17, that deals with the appointment of the property manager on page 16. Mr. Vice President, just a couple of observations here for consideration by the Honorable Attorney General. For the trustees and the deputy trustees, as outlined in clause A3 and A2 and A3 for the trustees, it's just that the qualifications and experience of the property manager submitting should be stated as well. Because the powers of the property manager within this legislation is extremely far-reaching, not necessarily on par, but very close to that of the trustees. And clauses A2 and A3 spells out the qualifications for the trustees. And I'm submitting that qualification and experience for the property manager should also be spelled out here. And in particular, the experience for the property manager should include specific experience for a significant period of time in property management. Also, Mr. Vice President, the conflict of interest and resulting penalties are not given for the property manager, as is done for trustees in clause 15. And employees and experts hired by the agency as per clause 19.5, 19.6, and 19.7 of page 19. For both trustees and the employees and agents and experts, there's a definite statement about conflict of interest and the resulting penalties for the offense, if there is a conflict of interest. So I'm submitting that the property manager should also be subjected to similar conditions. Mr. Vice President, in going through the respective clauses for the powers and duties of the trustees and that of the property manager, I think most likely because of the limited time to review things in a bit more detail, is to me there appear to be some duplication of responsibilities between the trustee and the property manager. And of course, for the civil asset trustee, the powers and functions are laid out in clause 14 of page 13. And for the property manager, clause 17, page 16. And both speaks about managing and realizing or dealing with property. In the particular case of the property manager, as receiver in terms of clause 19.6. But if we look at clause 17.9a on page 18, the responsibilities that are stated there for the property manager is almost the same as that for the trustee. For instance, under clause 17.9, on page 18, to ensure property, that same power is given to the trustee under clause 14.2g. Destruction of property that has little value for the property manager is also stated for the trustee under clause 14.2h. And clause 17.9c, again, destruction of property that is inherently dangerous is also given for the trustee under clause 14.2i. And donation of property for humanitarian purposes under clause 17.9 is also given for the trustee under clause 14.2j. I'm just saying an apparent duplication of responsibilities. And if we go to clause 45.6 on page 43, Honorable AG, the vesting of forfeited property, that clause specifically says directly to the property manager. And again, I'm asking, why not the agency instead of directly to the property manager? So in terms of the trustee and the property manager, a lot of the powers of the property manager is spelled out in clause 71 on page 60. And in terms of this separation of duties and responsibilities with the property manager and the trustee, the civil asset trustee, is it the intention of the legislation to deliberately have a hierarchy between the parties involved, the persons involved, where the property manager is directly reports to the trustee and take instructions from the trustee, or the property manager is just free to act in accordance with the powers and the functions that is outlined in this legislation. Because in clause 71.1, it says the civil asset trustee must also apply for the property manager to be appointed to manage the property relative to the property restriction order or a civil asset forfeiture order. So I'm just wondering whether the property manager's role only kicks in when the civil asset trustee applies to the court, the High Court, for the property manager to be appointed to manage a property relative to the property restriction order or a civil asset forfeiture order, if that application in the court by the civil asset trustee is the kickstart for the property manager to act under this proposed piece of legislation. So I'd just like the Attorney General, probably in his wrap-up, to, if it merits consideration, to please address that observation. Mr. Vice President, I go to clause 55 on page 50. And clause 55 of the legislation deals with companies as one aspect of the recoverable property. And the way it's outlined here in all of these subclauses 1 to 4, my interpretation is that the agency may apply to ask the court for either for the current manager of the business to continue its operation, or for the court to appoint a contracted manager to take immediate control of that particular company. And I'm just asking is that rather than engage, for the agency to engage in the continuation of the operations of a company under this act, should not the approach be that the agency, through its trustee or property manager, acting as a receiver, seek to wind up the company, recover the assets under the act, dispose of the assets of the company as provided for under the act, rather than seeking to continue the operations of the company, because it does not really give a time limitation here. There's no time that is mentioned or anything like that, because it means the agency getting into the business of running companies. And I query whether or not that should really be the intention of the agency in this case. And Mr. Vice President, my last point is Senator Vieira did raise this point about compensation. Clause 61. Under Clause 61 is that if there is a refusal by the High Court to grant the preliminary unexplained wealth order, if there is a refusal by the court to grant this order, is whether or not compensation should be addressed at the same time for the defendant. Because if the defendant is not given that opportunity, what happens is that the defendant has to go through a whole process of seeking redress. And as mentioned by Senator Vieira, whether we should not be given consideration that compensation be addressed at the same time on refusal by the High Court to grant the preliminary unexplained wealth order. I thank you, Mr. Vice President.
Minister of Public Utilities.
Mr. Vice President, thank you for recognizing me and for giving me the opportunity to lend my full support for this bill that is before the House. Mr. Vice President, this bill before the House is a product of three very important contributing factors. First, is here because of the hard work of a team of technocrats that worked with the Attorney General and, of course, the hard-working people that work in this Parliament, who I feel deserves their recognition for bringing this piece of legislation. This bill is also the product of a unique feature, one that happened in the lower house, where the opposition actually acted in what I should say a very responsible manner. And during that session, the opposition was able to help by all of their 8 contributions to craft the bill that is before us. So I think those 8 contributions that was mentioned, I think they're deserving of some degree of recognition for bringing the bill into this form because of those 8 recommendations that were brought, a full total of 8.
Mr. Vice President, just for the record, they were not 8. I just want to correct.
I mean, I think by now you know the procedures. Either you're raising on a point of order or you're asking the member to give way by way of his contribution in order to make a statement. So which is it that you're doing? Point of order, you're asking the member to give way?
I will deal with him later, Mr. Vice President.
Senator, I mean, there's no dealing with anybody later. Just, Senator.
Mr. Vice
Senator,
President.
I mean, okay, take a seat, take a seat. it's a language. We don't deal with anybody later in this chamber. As much as we understand what you mean, just be very careful with the choice of words and the language, right? And I'm just reminding you about the procedure as to point of order, or you're asking the member to give way. Minister of Public Utilities, continue.
Thank you very much for your protection.
And Senator Amin, again, now, the choice of language you just use, and then the gestures after could be taken the wrong way. The pointing at across the floor, we don't do that. We try to maintain a particular level of decorum. You don't need to respond. Thank you. Minister of Public Utilities.
Thanks again, Mr. Vice President. And of course, I see the TikTok, my time is going, which is probably what it is that they really would like to achieve. Mr. Vice President, the bill also is also representative of the political will of an administration whose ethos is founded in good governance, transparency, and accountability. It is representative of an administration whose policies have constantly resulted in progressive economic and social and cultural development of this country, and whose vision for Trinidad and Tobago is aimed at ensuring that we lived in a just society where everyone, regardless of race, creed, political affiliations, can have a fair chance to achieve success in this life. Mr. Vice President, a country cannot progress unless it has at its helm an administration whose philosophy, governance style, and policies reflect those critical features. And thankfully, since September 2015, this style of government has been restored to Trinidad and Tobago. Mr. Vice President, being a member of this cabinet, I had the opportunity to work and be part of this bill from its inception. And at first, I support this bill for three very important reasons. And I like the line that was taken by Senator Dillon-Remy, and I will address part of that and support that position. But first, Mr. Vice President, as you are aware, money laundering provides the impetus for the illicit world to expand their criminal enterprises. And owing to the increasing interconnectivity nature of our existence, this expansion is now taking place across the whole globe. Crimes of this nature have become increasingly more complex and multidimensional and international in scope, and requires all nations to adopt a common approach to tackling and eradicating these ills. FATF, which was the organization which was formed in 1989, was given the global mandate by the international community to develop measures to treat with money laundering. FATF is therefore a product of the global community firm intention to A, remove the surge of money laundering, terrorism, and the proliferation of weapons from life as we know it today, and 2, mitigate the devastating impact that these crimes and other illicit activities have on every country's governance, economy, and social well-being. FATF, as we all are aware, developed 40 recommendations to guide the global community response to international crime activities. By becoming a member of FATF, and in this region, CFATF, Trinidad and Tobago made a political commitment to ensure that it creates a legislative and institutional framework to support the implementation of the 40 FATF recommendations. In our 2015 CFATF mutual assessment, an assessment, I dare say, that we have heard in this House that was brought upon quickly by ourselves, by the outgoing government, who brought it upon ourselves and did nothing to make us prepare for it So we are here because of the actions because of the irresponsible action of bringing us into the firing line by the last administration. But those coming out of that mutual assessment, this country was deemed to have deficiencies in our implementation and operationalization of recommendation number 4 and recommendation number 38. Of the 40 recommendations, in respect of recommendation number 4, we were deemed to be largely compliant with 2 major deficiencies being identified. The most relevant for the purpose of the debate today is as follows. A, that there were limited measures, and this came out of the FATF recommendations. There were limited measures which would enable Trinidad and Tobago to void actions, and this would prejudice its ability to freeze or seize property subject to confiscation. In recommendation number 38, the rating was again effectively a lower rating, as we were deemed to be partially compliant. The following deficiencies relevant to the legislation today were identified. And again, I quote, requests from non-Commonwealth-based countries for freezing, seizing, and confiscation of assets was subject to limitations and qualifications. And again, 2, FATF recommendation number 38 again says no provision in place for non-conviction-based confiscations. Those came directly out of FATF recommendations, the global framework which we all agreed to be part of. The bill before us today represents the plugging of the legislative and institutional gaps that resulted in the rating that we received in 2015. Mr. Vice President, the focus has always been on our FATF compliance, and we continue to say that as this is this country's immediate concern. I would, however, like to inform my colleagues on both sides and in the independent benches and the broader national community that Trinidad and Tobago has signed and ratified the United Nations Convention Against Corruption, which also imposes an international obligation for this country to implement mechanisms to prevent corruption. Through a legislative framework geared at facilitating the tracing, freezing, seizure, and forfeiture and return of assets stolen through corrupt practices. The United Nations Convention Against Corruption outlines obligations that requires party states to have a mechanism for the recovery of illicitly acquired assets. These mechanisms must include, and again, I quote, procedures to permit state parties to participate as a private litigant in the courts of another state party, allowing state to recover corruption proceeds as a plaintiff in its own actions and as a claimant in the forfeiture proceedings or as a victim for the purpose of the court order restrictions, Article 53. B, domestic legislations that enables the state to recognize a foreign forfeiture order and to freeze the forfeit assets derived from corruption in a foreign state through its own investigation, Article 54. Domestic legislation that allows non-convicted-based assets to be asset forfeiture, Article 54, paragraph 1C. Mr. Vice President, while our immediate impetus is enshrined in this legislation by FATF and CFATF, in so doing and in putting this legislation in place, Trinidad and Tobago will be implementing a regime that fosters compliance with the United Nations Convention Against Corruption as well. Mr. President, based on the fact that the mechanisms of this bill are not only part of the FATF regime, but also part of the United Nations regime, Trinidad and Tobago will be joining a long list of countries, including nations as far away as South Africa and Thailand, and even including several of our regional colleagues, Antigua and Bermuda, Jamaica, the Dominican Republic, St. Vincent and the Grenadines, in passing legislation of this nature. Secondly, Mr. Vice President, I gave my unequivocal support for this bill because I see this bill as a critical tool in implementing mechanisms that are geared at curbing the devastating impact that money laundering can have on economic development. Mr. Vice President, economic development hinges heavily on diversification of the economy, and we have heard a lot about that. We need to diversify. And diversification of the economy entails creating an enabling environment for local business to flourish. And that will, and in our ability to attract foreign investment. Those are two things that you need to happen, an enabling environment for your business to flourish. And if you want diversification, you must be able to attract foreign investments. This administration is committed to creating an environment that will see every aspect of our economy flourish. It is therefore of top priority for this administration to remove any negative cloud that may exist over the integrity of this country's financial sector and the stability of our economy. Mr. Vice President, this administration has adopted a well-planned approach to economic development that started way back in our 2015 PNM manifesto. Permit me to quote directly from the manifesto, which clearly articulated this administration's vision for the financial services sector. And I quote, "One area of diversification with great potential is the financial services sector. Trinidad and Tobago has already been recognized as the de facto financial center of the English-speaking Caribbean, and the PNM government will seize the opportunity to widen our horizons and look towards HS China in particular. We will seek to encourage branches of the new development bank and the two state-owned Chinese banks to anchor tenants in our Trinidad and Tobago International Financial Center. These branches will then serve as an intermediary in challenging the resources from lending agencies to funding projects in Latin America and the Caribbean." Mr. Vice President, the commercial banking sector, the commercial banking sector has taken the lead in going out there and cementing our role as the financial hub of the Caribbean. If you notice recently, Republic Bank, one of our leading financial institutions, they have recently gone out and expanded. They have gone out there knowing that they have the support of a proper legislative framework behind them. They have gone out there and they have bought branches of Scotiabank throughout the Caribbean. They have bought banks as far north as the Cayman Islands. Right? They have gone, as we know before, they have gone to as far in the African continent and West Africa in Ghana and expanded. So they are doing their part. And therefore, it is very important, and I will dare say that as a result, if you'll allow me to just segue for a minute, as a result of the good work of this government through NIF, the whole of Trinidad and Tobago now will have the ability to participate in the success of that institution. But it is therefore important that we create an environment that will allow for institutions like this to be able to continue to grow. And therefore, an institution like this will not be allowed to go if we have an environment where we are not compliant with basic FATF recommendations. It is something that we need to do. It is something that we owe. A lot of times people talk about diversification. But the reality is, if you do not have an environment to facilitate diversification in a proper manner, then it will never happen. And all you will be doing is old talking. So, Madam President, Mr. Vice President, again, I support this bill because of its trust that it allows us to help in the fulfilling of our own mandate, to help diversify the economy by ensuring that the financial services sector is strong, is reliable, and has the laws with the teeth to prevent the scourge of money laundering. We have to remember, Mr. Vice President, this thing called money laundering is wrong. It is the environment around us. It is there. We heard the senator mention about in the last FIU report, we had close to $21 billion worth of funds that attempted to get into the financial sector. That is the environment that we live in. We cannot put our heads in the sand and think, well, wow, this is not required. It is necessary because of what it is, $21 billion. That represents close to 50% of our annual budget and 15% of our GDP. And that is cash. That is cash. If you add then other resources and other assets around, you are talking about over $100 billion and counting. So we are living in this environment and we know what is around us as regards to money laundering and illicit activities. And therefore, it is imperative, and I support this legislation because it puts the mechanism to give the authorities a fighting chance. Finally, Mr. Vice President, I support this bill because I see the mechanisms enabling the forfeiture of assets derived from criminal activities as a necessary tool aimed at curbing the devastating impact that money laundering and other illicit activities can have on the social well-being and the social fabric of our nation. And I couldn't agree with you more, Senator Remy. Mr. Vice President, by sheer force of how our society develops, mutually, there will be economic divide. There will be some persons who, because of innovation and by honing their entrepreneurial skills, will generate wealth by enabling them through legitimate business. There are other persons, due to their lineage and the fact that they were born into families that had wealth, by legitimate means, their generations will also enjoy the wealth that was received as because of the hard work of their parents. But unfortunately, Mr. Vice President, that is not the only means through which persons amass wealth. The activity of criminal wrongdoing, whether it is organized crime, criminal enterprise engaged in drug trafficking, terrorism activities, arms, or blackmailing or credit card swindling, also allows persons to amass unprecedented amount of wealth. With the proliferation of these developments, a progressive society has to ask itself, the big question that we are reaching is, how will the just survive in the world of the unjust? How will the just survive in the world of the unjust? It is therefore incumbent on the government and any progressive society to implement legislative and institutional and administrative measures to ensure that persons engaged in illicit activities and criminal wrongdoing who amass wealth must not be able to profit from it. The concept of generation stealing must stop. Mr. Vice President, it is also incumbent on a government in a progressive society to ensure that the proactive measures are implemented to prevent that society from becoming a safe haven for illicit activities and wrongdoing. In taking this step, the government will be preventing a social decline and a decline in the overall well-being of a country. Mr. Vice President, what this bill therefore seeks to do is, one, provide a fair and just mechanism to allow the state to correct the kind of social injustices where people gain wealth through illicit means. And 2, provide a mechanism to prevent illicit activities and criminal wrongdoing from taking root in this society and disadvantaging legitimate law-abiding citizens from progressing. Mr. Vice President, this kind of legislation sends a strong message to criminal element, corrupt politicians, and anyone who is involved in the underworld of crime that Trinidad and Tobago is not going to tolerate this type of activity any longer. It sends a strong message that this administration has the political fortitude to tackle crime head-on by implementing systems, processes, and procedures to ensure that people who engage in crime no longer get the unfair advantage over law-abiding citizens. And I want us to understand that when someone gets money through illicit activities, they have a competitive advantage over you who did not. And in any way, in my young age, I was a sprinter. I was an athlete, yes. Look at this. You could see it, Mr. Vice President. And therefore, even in those days, we understand even in sport, and you could understand running 100 meters. It could be who. When you get a jump start in 100 meters, the chances are, if you are allowed to continue, you could win the race. Then you could win the race because you have gotten a jump start. And regardless of who, we saw it happen to Mr. Bolt at the time in the World Olympics. When he got a jump start, you know what happened? Nobody allows you who get a jump start to say, well, okay, you get it already, go on. No. In sport, you are called back, the race is stopped, you are taking it, and you are actually thrown out of the race. In a similar way, you cannot allow to run a society whereby people get a jump start. You're already hearing that people, $21 billion trying to find its way into the system. Yep. They got a jump start. If you leave them with that money, or you don't find a mechanism to equate it, what do you think is going to happen? You are going to create a society where the people who are legitimate business people will no longer be able to operate. And that is what you have to stop. And sometimes when you have to stop these things, it might not be easy, it might not be hard. I remember looking at that race with Usain Bolt, and I said, oh my gosh, everybody was waiting for him to win that race. But you got to do what you have to do, because it is the right thing to do. And we are creating a society, not for now, but for not only but for our children and our children's children. And we need to send the word out to them that that kind of bad behavior has to stop once and for all. So let me move on and talk a little bit and talk at this bill about what are the provisions that this bill means to achieve and what it intends to achieve and how the bill achieves this. Mr. Vice President, the statutory regime governing criminal law comprehensively deals with the forfeiture upon conviction of a crime. The common law, through the Moravian injunctions and other remedies, offers a civil relief that facilitates, in some measures, the confiscation of property. That presently exists. There was, however, a gap in our law that did not cater for one of the primary features of the international community response to corruption, money laundering, and other illicit activities, namely the non-conviction-based forfeiture. The legislative systems being implemented by this bill introduces such a mechanism to our national legislative framework. The legislative scheme in this bill is firmly linked to the existing regime of criminal offenses under the Proceeds of Crime Act. The offenses in question which will trigger the mechanisms of this bill are those listed in Schedule 3 of the Proceeds of Crime Act. Mr. Vice President, this is the first safeguard offered by the bill, as it severely limits the scope and applicability of the provisions of the legislation. If you are not engaged in activities identified in the Proceeds of Crime Act, you are not going to be subject to the remedies of this bill when it becomes law. The legislative scheme in this bill also establishes a mechanism to identify, trace, and evaluate properties that will be linked to criminal activities that should be subject of confiscation. This is achieved by virtue of Clause 8 to 12, which establishes the Civil Asset Recovery Management Agency as an independent entity responsible for the recovery, management, and disposal of property in respect of offenses identified under the legislation. Clause 14 delineates the agency's function, which includes securing the detention, custody, and prevention of properties through obtaining either a property asset restriction order or a property asset forfeiture order. Clause 30 to 57 establishes the transparent process for civil assets recovery. Clause 45 empowers the court to grant the civil asset forfeiture order even when a person may not have been convicted of an offense under Schedule 3 of the Proceeds of Crime Act. This clause, Madam President, is one of the crown jewels of this bill. This clause, which implements non-conviction-based forfeiture, is in taking this step, Trinidad and Tobago makes significant progress in implementing its international obligations. By doing this, we join, as I said before, a number of other countries around the world who have previously taken this step and has gone out there and put legislation to give their law-abiding citizens and to normalize the society once and for all. The legislative framework in the bill institutes a system in which persons can be called upon to explain their wealth. Part 5 of the bill, in particular Clause 58 to 67, empowers persons currently under investigation relating to the offenses under the Proceeds of Crime Act to explain their wealth, and the court to grant unexplained wealth orders where the value of a person's assets exceeds the value of his wealth lawfully obtained. Madam President, this is a revolutionary tool in the context of law enforcement in this country, and this is exactly the kind of transparency, accountability, and social justice that this country needs to restore our average citizens' faith in our institutions. The legislative framework establishes a framework that will allow Trinidad and Tobago to lend its support to the international crime-fighting network through mutual assistance. This facilitates expeditious actions to be taken in respect of the international fight against illicit activities. The AG in this legislation is given the power to declare a treaty as having force of law in Trinidad and Tobago by order subject to negative resolution in Parliament. The AG now has the power to enter into reciprocal sharing arrangements for property forfeiture and disposal of under the Act once proclaimed and properties disposed of or forfeiture by foreign states. The AG is empowered to seek international assistance in enforcing property restrictions and confiscation orders or unexplained wealth orders. Madam President, Part 4 of the bill is therefore of a critical tool enabling Trinidad and Tobago to seek justice for crimes under the Proceeds of Crime Act in other territories and facilitate foreign countries being able to seek justice in our jurisdiction. Madam President, it is interesting to note that while this country was able to benefit from a legislative framework in the United States, which allow a country to pursue restrictions and civil forfeitures, there is no equivalent mechanism to date to facilitate the type of actions happening here. Under the stewardship of Attorney General John Jeremy, QC, SC, this country was able to institute proceedings in the U.S. against persons alleged to be involved in the Piarco airport scandal. And as a result, the government receives restrictions from the parties and the individuals that were involved in that particular scandal, as was reported in the newspaper. While we consider how we want to, when we look at what is happening in this particular legislation and people contemplate whether they want to support it or not, I want us all to reflect upon the fact that this brings to the forefront exactly the kind of assistance that our government relied on in the Piarco airport scandal. This bill seeks to implement the kind of international cooperation that is necessary to stamp out the surge of money laundering, corruption, and terrorism globally. I stand here today very proud of the fact that I am part of an administration that had the political will, the vision, and the foresight to see that now is the time to take measures in this particular regard. Now is the time because it's good for national development, the preservation of the integrity of the global financial system, and the furtherance of the mechanisms to conduct the growing threat against international security. Madam President, this bill does not change the lives of law-abiding citizens in any way. I want to repeat that. Madam President, the Civil Assets Recovery and Management and Unexplained Wealth Bill 2019 does not change the lives of law-abiding citizens in any way. The provision of this bill, once enacted in law, will impact the citizens of this country who are involved in activities listed under the Proceeds of Crime Act and who are under investigations for any of the offenses listed in the Act. These are the only persons that have anything to worry about. And there are lots of people who talk about, well, whether or not I'll have records or don't have records, and well, what's going to happen? If you're innocent, Madam President, you know, I came from the banking sector, and if you want to understand, you lose your records, you could go to the banking sector, you could ask for records. They are called upon by law to have records, to keep records for 14, 20 years. They have to keep records. We have, in a digital world,
Minister, you have 5 more minutes.
There are a number of places that will allow for us to be able to have the particular records. That one, if they require records, they will be able to get records if you want them. In a digital world, records are all over the place. You could have access to them. Madam President, earlier I mentioned the countries that have adopted non-conviction-based forfeiture legislation. But it's important to note that these countries are not aberrations of the modern world or rogue countries acting on their own accord. I say this because there are several international organizations and regional groups that support the implementation of non-conviction-based forfeiture schemes other than the United Nations and FATF. These bodies include, and I put on record, the Commonwealth Secretariat, the European Union, the G8 countries. All of these countries have recognized the importance of this type of legislation and actually support its implementation because they understand that, yes, what we are fighting against is bigger than all of us, and we all have to fall in line to make sure that we get it right. Madam President, while we are here in Trinidad and Tobago and having academic debates on the propagation or whether the legality and the constitutionality of mechanisms. Other jurisdictions have crossed this hurdle and have implemented legislations to give effect to non-conviction-based forfeiture. In this region, as I said before, Trinidad and Tobago lags behind on several of our CARICOM's sister countries, which have already implemented this kind of legislation. Madam President, I suspect, as you said, I only have a few more minutes, so let me then quickly move on. Mr. President, history may not look so kindly. You know, at the end of the day, I am convinced that history will look kindly upon our government and this government for putting in place this type of legislation and looking towards getting this type of legislation in place. But you know, we have had in the previous regime, there were a number of, over their 5 years, there were at least 10 pieces of critical legislation that was attempted to be put in the first session, in the second session, in the third session, in the fourth session, and in the fifth session. All of these legislations that were attempted to be put before to try to correct situations, it was about putting it in, and then all of these legislations eventually lapsed, 10 of them. Madam President, in every nation's development, the people have critically assessed what kind of society that we wish to live in, and which society of governance that we wish to have as a country, to have the country move along the path of development. This administration answers the call of the people of this country in 2015. This administration, over the last 4 years, has shown that it has adopted a holistic approach to government that will facilitate all aspects of development. This administration has also shown that it is prepared to change the image of the criminal justice system in this country. Madam President, through you, I want to pose a question to members of this House and to the national community at large. Do you want to continue living in a society in which persons who are alleged to be involved in the largest corruption scandal that this country has faced cannot have their day in court to respond to the charges laid against them some 18 years after charges were laid? Or do you want to live in a country that has a suite of progressive legislation that allows the state to implement the policies, institutions, and administrative mechanisms to curb the surge of crime that is negatively affecting our society? Or do you want to live in a country with a robust legislative framework treating with the regulations of various stakeholders who are susceptible to the abuse of criminal elements, who engage in activities such as anti-money laundering, terrorism, and the proliferation of arms and human trafficking and drug trafficking? Do you want to live in a country with a comprehensive penal code addressing offenses relating to these activities and other criminal activities that are emerging as serious threat to the international community?
Minister, your time is up. Senator Ramdeen.
Madam President, good afternoon, and thank you for the opportunity to contribute to this debate on the Civil Asset Recovery and Management and Unexplained Wealth Bill 2019. Madam President, allow me first to apologize to you and to the Senate for not being here when the session first started this morning. I noted that the Honorable Attorney General referred to public lawyers as fair cookie cutters. So I was cutting some cookies in the Court of Appeal, and the state cookie crumbled this morning, and I'm here now to deal with this aspect of my cookie cutting. Needless to say, Madam President, just as a passing before I really get into the meat of this, a number of cane farmers will be happy because the state lost their case this morning, and they will be benefiting from the efforts of the United National Congress. But, Madam President, let me first respond to what my no, it was not default judgment. But I'll get to that. I'm not going to get tied up with this, distracted by the Attorney General this afternoon, Madam President. The Honourable Minister of Public Utilities indicated that he wanted to congratulate the opposition for the 8 amendments that were brought to the legislation. So I just counted the number of amendments. This bill was laid by the Attorney General. Then it was debated in the other place. The bill that was laid when it was laid, after it was debated in the committee stage, it was the subject of 35 amendments. So in cookie cutting mode, do not bring half-baked legislation to the House and then come to talk about how many amendments. It was a half-baked piece of legislation that was brought. You bring a bill with 76 clauses, and when you finish debate it in the lower house, it has 35 amendments, and you come to talk about who contribute to which and how many amendments. It is, Madam President, it is unsatisfactory, let me put it kindly, to bring a piece of legislation, and on your own admission, the piece of legislation that you brought should have been amended more than 20-something times, and you're proud about that. Well, that may be the position with the government. But you see, Madam President, this legislation had to be amended from what was originally presented by the government and what was approved, Madam President, by the Cabinet. Because when it was laid, it got the approval of the Cabinet. That's the way we operate in a democracy under this Constitution. But what happened is this, as I understand it, there was some pushback in the Cabinet, and that is why these substantial changes had to be made to this piece of legislation. Because when you look...
Senator Ramdeen, we have a bill that has come from the other place here, and I really want us to focus more on what is here. Now, other speakers have spoken about what happened in the other place. I'll ask you to not to confine yourself to a few comments and move on to the bill that is before this chamber, please.
Thank you, Madam President. I'm guided. You get on. The Attorney General told us that the Attorney General's office examined legislation. We heard about all the different places that legislation was examined before they brought this bill to the Parliament. So let me get on to what the Attorney General said. The Attorney General called out almost every province in Canada. They said that they went to Canada and they look at the legislation in Canada. Well, I do a little bit of research about Canada too, so let me get on to that. In 2015-2016, the Canadian Constitution Foundation Institute for Liberal Studies produced a paper on civil asset forfeiture in Canada. Now, this is not a fly-by-night organization. The Canadian, let me just lay the foundation. The Canadian Constitution Foundation is a registered charity, independent and non-partisan. We defend the constitutional rights and freedoms of Canadians in the courts of law and public opinion. So they produced a paper on this thing called civil asset forfeiture. It starts off by the executive director, Ms. Marnie Subkoff, saying, you may not know anything, I'm quoting now, you may not know anything about civil forfeiture laws, and you may see no reason to change that. These laws sound like something that only affects criminals. And indeed, that is how they were initially sold to the public, as a means of government to take criminal property and fight organized crime. Quite similar to what we are being told now. Quote again, unfortunately, civil forfeiture laws allow provincial governments to seize property not only from criminals, but also from people who have never been charged with or even suspected of a crime. All the government has to show is that the property at issue was used by someone as an instrument of crime in inverted commas, or was the proceeds of crime, and they may take the property from its rightful owner with no compensation. These laws are not fair. In fact, the Canadian Constitution Foundation believes they are unconstitutional, and we'd welcome your support in fighting them. So that is the Canadian Constitutional Forum. So we heard about the different states. So let me go to the different states. British Columbia, they have a Civil Forfeiture Act 2005. Alberta They have a Victims Restitution and Compensation Payments Act 2001. Saskatchewan, Seizure of Criminal Property Act 2009. Manitoba, Criminal Property Forfeiture Act 2004. Ontario, Civil Remedies Act 2001. Quebec, an act respecting the forfeiture, administration, and appropriation of proceeds and instruments of unlawful activity 2007. New Brunswick, Civil Forfeiture Act 2010 and Management of Seized and Forfeiture Property Act 2012. Nova Scotia, Civil Forfeiture Act 2007. So those are the states, Madam President. So what this organization did was that they examined the laws of all of these countries that we in Trinidad and Tobago have used as a precedent to come up with this legislation, this Explain Your Wealth. Okay. The basis upon which they examined the Canadian forfeiture laws, upon which our legislation, we've been told, has been based and was studied in order to come up with this piece of legislation that we have, is this. The Canadian Constitutional Foundation assesses provincial civil forfeiture legislation based upon the following criteria. And the reason why I want to set this and put it on the record, Madam President, is because I want to show and demonstrate how this legislation has worked in a first world country that has all the resources to implement the legislation and to ensure that the legislation is to achieve the legitimacy. They're not like Trinidad and Tobago, where the DPP do have an office, the 50, I want to put it on the Hansard, the 50 highest posts in the Customs and Excise Division in Trinidad and Tobago is acting. It is vacant. There are people acting in the 50 highest posts in Customs and Excise. But you come here with a piece of legislation. You don't bother to fix that, because that's not important to fix before you bring the legislation, where the Comptroller of Customs and Excise is one of the people who is given the power under this piece of legislation to implement this legislation. Don't bother to fix the 50 posts that are acting. You come here to tell us about Explain Your Wealth. So this is what this is the basis upon which they assessed. Can the province use civil forfeiture to strip owners of their property under the mere suspicion of an illegal act, or when they are innocent third parties? And Madam President, let me just stop. I don't want to go and point out every single section, but this entire act is based upon powers that are exercisable upon suspicion. So it is in paramateria to what we're talking about here in Canada. How much discretion is afforded to judges to craft forfeiture orders that are proportionate and satisfy the objectives of deterring illegal acts and compensating victims? For what offenses can a province initiate civil forfeiture proceedings? Do the revenues collected by successful civil forfeiture proceedings go towards victim compensation? And does the province provide a clear and transparent financial disclosure of all revenues raised through civil forfeiture proceedings and of compensation provided to victims? Every single one of those factors are directly linked to the legislation that we are asked to consider and we are asked to pass this afternoon. So, Madam President, can I please allow you, Madam President, to have the wisdom of what this Canadian Constitutional Foundation, the grades after assessing, it's 2015, 2016, after they assessed each province, here what they come up with. British Columbia, F. Alberta, C. Saskatchewan, D+. Manitoba, F. Ontario, F. Quebec, C. New Brunswick, D+. Nova Scotia, D+. And this is what we are told is the basis for the legislation that we have before us. If it didn't work in Canada, where they have all the resources, first world status, they don't have the problems of police corruption that we have, right? They don't have the problems of resources that we have. It's going to work here. Then we were told about a case from the European Court of Human Rights. Gogitzi and another versus Georgia, application number 3686205. The Attorney General said this is a real good case. We should read it. All the international obligations, documents, protocols is in this. This support the legislation. So I did that. I read it. Of course, under the heading Constitutional Proceedings, which is in page 6 of the judgment to the European Court of Human Rights, it says, on the 6th of December 2004, the first applicant lodged a constitutional complaint. He argued that Article 3711 of the Code of Criminal Procedure and Article 21, paragraph 5 and 6 of the Code of Administrative Procedure, adopted on the 13th of February 2004, were contrary to the following constitutional provisions: Article 14, prohibition of discrimination; Article 21, protection of property; and Article 40, presumption of innocence; and Articles 42, paragraphs 2 and 5, no criminal punishment without law, and prohibition of retroactive application of criminal laws of the Constitution of Georgia. Madam President, I've read this judgment. So having read the judgment, I just want to put on the Hansard that it's a very dangerous thing to be taking a judgment that comes from a different jurisdiction, that applies different laws to what is our societal position in Trinidad and Tobago, that is different from the Council of Europe, and say that we must just apply wholesale across the board. So of course, they'll say that that is cookie cutting. But let me not cookie cut. So let me just cement that submission that I made by referring Malady to a judgment of the Judicial Committee of the Privy Council, something a little bit closer to home, because it's our highest court. In the decision of Lendo and others versus the Attorney General of Trinidad and Tobago. So I would have thought this was a judgment that would be easy at hand. So at paragraph 60 of that judgment, that was delivered by none other than Lord Hughes, this is what they say about this kind of learning from the European Court of Human Rights. It is inherent in this concept of fundamental rights that different jurisdictions may develop the law in ways that reflect their own constitutional traditions, legal procedures, and collective values. The European Court of Human Rights has been the most prolific single international source of judicial decisions on human rights, which in one form or another are protected under many instruments in many countries. And listen to this, Madam President. But in considering persuasiveness of its decisions in Trinidad and Tobago, some significant features of its jurisprudence must be borne in mind. First, the Convention is a regional human rights instrument. And as the Strasbourg Court observations in Tyler show, the values which it seeks to apply are those of the member states of the Council of Europe, so far as it is possible to generalize about them. Criminal law and procedure and penal policy in general are areas in which accepted practices are particularly liable to diverge as between different jurisdictions and different parts of the world, where patterns of criminality, social attitudes to crime, and the practical implications of penal policy may not be the same. So don't just pick up something that sounds like it supports the position and come to the Parliament and read it out and put that as gospel, right? And claim that as to be the gospel. And that is not the position, Madam President. It is not. Let us deal with what is before us here. So this is supposed to solve, we heard the proverbial beginning of the contribution by the Attorney General, which we are accustomed to now. How many courts they open, how many criminal procedure rules they pass, how many judges have been appointed. But, you know, they're doing very well on crime, Madam President, very well. The government should be complimented on the way they're dealing with crime. Because for April, today is the 15th, and they've had 21 murders for the month of April already. So they're doing real good for the last 3.5 years with respect to crime. And then the institution that is supposed to operationalize this is called the judiciary. Well, in a political meeting last week, the Attorney General said that there was a particular senator who was traipsing up and down the court with Watson Duke. Well, I know that's me. And I will continue to traipse up and down with the people who must put their shoulder to the wheel, right? And make sure that when legislation is passed, they have a court system that could operationalize it. I do apologize for that. Because
Mr. Ramdeen, I really, somehow, I don't think it is right to be talking about matters that you're involved in. I think you should stay away from that. I think I told someone else, speak generally. Don't go into specifics, okay?
I'm not involved in any matter. I was just performing my role as a member of parliament and as a member of the opposition. I have no court, I just want to make it clear, I have no court matter that deals with the PSA and what is going on in the court. But what is troubling, Madam President, is this. We expect to pass this legislation. An essential component of the government, of the state, that has to implement this legislation is the courts. And just like how I make complaint about the fact that Customs and Excise, Controller of Customs and Excise, they don't have proper staff, just as how I make complaint about the Office of the Director of Public Prosecution doesn't have an office in South, looking for an office in Port of Spain, and still doesn't have staff because 75 people out of 128 on the establishment are appointed. It is the same complaint with the court, and it's not getting any better. So one has to take that in the context of what it is. Now, Madam President, this legislation that has been proclaimed to be the savior of Trinidad and Tobago has some very important provisions with respect to the Office of the Director of Public Prosecution. And it is important for us to examine the role that has been placed upon the Office of the Director of Public Prosecution in this matter. And I make specific reference to Section 31. So let me lay the foundation for that. We've been told frontally that this is not criminal legislation. The reason why it's not unconstitutional is civil legislation. And that's why it's not unconstitutional. You don't have any of the attached rights that a criminal defendant will have. So you're in rem, and you're not in personam, and therefore it's civil. Everything here is civil. So let's go. Section 90 of the Constitution. The provisions of this section shall, subject to Section 76(2), have effect with respect to the conduct of prosecutions. Prosecutions, Subsection 2. There shall be a Director of Public Prosecution for Trinidad and Tobago whose office shall be a public office. The Director of Public Prosecution shall have power in any case in which he considers it proper to do so. So, Madam President, the Director of Public Prosecution is a creature of the Constitution. He has the powers that are given to him under the Constitution. And what are those powers? A, to institute and undertake criminal proceedings against any person before any court in respect of any offense against the law of Trinidad and Tobago. B, to take over and continue any such criminal proceedings that may have been instituted by any other person or authority. So in A, you have undertake criminal proceedings. 2, take over and continue criminal proceedings. C, to discontinue at any stage before judgment is delivered any such criminal proceedings instituted or undertaken by himself or any other person or authority. Madam President, this power that the Parliament seeks to give to the DPP under this piece of legislation is this. Under 31 subsection 2, where upon receipt of an investigative report by the Chairman of the BIR, Commissioner of Police, Comptroller of Customs and Excise, the Director of Public Prosecution is of the view that A, there is insufficient evidence to pursue criminal charges for a specified offense. So I have no problem with that. That's the role, that is his function under Section 90. He has to determine on any given state of facts whether a criminal offense has been committed. But here it is. So he exercises powers under Section 90. No criminal offense. But there's sufficient evidence that the property is recoverable property. So, by the wave of this magic wand, the Director of Public Prosecution has now been given the power to give advice on whether there is recoverable property with respect to this report. Where does that power come from? Nobody has asked themselves, where does this power come from? We just slap it in a piece of legislation, and it arrives just like that on the scene, and it becomes constitutional and lawful, notwithstanding that nowhere it could be grounded in Section 90 of the Constitution. Good law, pass it, and see if it will work. But like Senator Mark has said, they have proclaimed, just like with the anti-gang, they want our support, you will get our support. You will fare no different with this than you fared under the anti-gang legislation that you said the police was crying out for. And, Madam President, let the people of Trinidad and Tobago understand. You see this idea that the government wants to take all the credit, right? Every time they talk about a criminal piece of legislation, it's the Commissioner of Police. Right? The Commissioner of Police is a member of the Cabinet. Is it not going to fool the population, you know? Because the state of criminality and crime in this country that we have today is worse than at any other time in the history of our country. And the blame will fall at the feet of the government of Trinidad and Tobago. So you can come with more legislation. You bring Explain Your Wealth. Well, we have about, the Minister of Public Utilities said he wanted to congratulate the opposition for the 8 amendments. We have about 60 coming this afternoon or by tomorrow. So we'll hear about that. Because that is the state of this piece of legislation that we have here. You see, Madam President, let me, you know, I was really amazed when I listened to everything that transpired in the debate before. Because you know what the government was saying? They were taking credit for who proposed which amendment and who is responsible for which amendment. No problem. I understand as a cookie cutter that at the end of the day, a comma could make the difference between a man's life and death in relation to a piece of legislation. But they want to talk about who makes big amendment and who makes small amendment, like, you know, you're obsessed with size. But let me point out some small errors that I'm sure that when this passed through the Cabinet, it should have been picked up. Section 32. Prior to application for a property restriction order under Section 33 or a civil asset forfeiture under Section 44, the agency shall, as far as possible, have an equity valuation done for the company which will be the subject of an order. So before the application is made, the legislation already provides, before the application is made, you know, that the company, right, will be the subject of so they determine the company is already going to be the subject of an order before the application is even made. Real good law here, man. Madam President, there's a provision here that deals with Section 41. This is the best I see so far. Section 41. Requirement to inform specified agencies of property restriction order. So this is a section, when the property restriction order is made, this is a section that operationalizes that process under this piece of legislation. So listen to what the government and the Cabinet and the Attorney General has presented to the people of this country. Where an agency makes an application for a property restriction order, I don't want to go through or read out the whole section really, but there's an order is made. The Registrar General, this is after the order is made, you know. The order is made by the court, right? Let me read it out just for emphasis, just to demonstrate the type of legislation that is brought here. Where an agency makes an application for a property restriction order under Section 33 in respect of land, the agency shall be treated as the person interested in any land to which the application relates or to which the property restriction order made on the application relates, and the agency may at that time request the court direct the Registrar General to restrict or prohibit dealings with the land. So this is how it goes. An application is made, the court makes an order, the agency asks the court to direct that the Registrar General deal with the property in a particular way. Listen to this subsection, Madam President. The Registrar General may, just 3 little letters, may, on an order being granted under subsection 1, enter the restriction in the relevant registrar. So here how this works. Here what we asked to pass. The court makes an order. The order is to direct the Registrar General to do something, a court order from the High Court. And you know legislation says the Registrar General may obey that if they want. So the Registrar General is given a discretion here to obey or not to obey a court order. Excellent. Couldn't be better. Here the next part. They have a section that deal, the same section, the same section that deal with the Registrar General, the same section dealing with the Commissioner of Transport. But here this one, the same cookie cutting, where the agency, your cookie cut subsection 1, you go down to subsection 2, where the agency makes an application for a property restriction order under section 33 in respect of a motor vehicle, the agency, well, lady, if other people want to contribute, I have no difficulty sitting down, I have absolutely no difficulty sitting down. I'm here to help the Parliament of Trinidad and Tobago, to help the people who couldn't help us in the first place. But you know they say pressure is burst pipe. Where the agency makes an application for a property restriction order under section 33 in respect of a motor vehicle, the agency shall be treated as a person interested in the motor vehicle to which the application relates or to which a property restriction order made on the application relates. And the agency may, at that time, request the court direct the Commissioner of Transport to restrict or prohibit dealings with a motor. So it's the same exact section, One dealing with land, one dealing with motor vehicles. Here what it says, Madam President. The Commissioner of Transport may, on an application under subsection 3, enter the restriction in the relevant registrar. You see, in one section, the identical power that is given to the Registrar General is given to the Commissioner of Transport. But in one section, the Registrar General must act on a court order. And in the identical section, which is clearly a mistake, that nobody bothered to pick up, is that the Commissioner of Transport will go and restrict your asset, which is a motor vehicle, upon the application being made. So no order is being made in this one. No order. He must just go just like that. An application is made, no order from the court. Just go and restrict your dealings with the motor vehicle. And they expect us to approve that and pass it. But it gets even better than that. Because the third one deals with ships. So the same subsection that you come to enact, that one you deal with land, one you deal with motor vehicles, now you come down to deal with ships. Well, the power to restrict the dealings with ships don't exist at all. They totally forget that one in this. And this, 76 clauses, pass through the Cabinet, the LRC, the CPC, all other C, and reach to the Parliament. And nobody bothered to pick up on these fundamental things, the little 3 letters, the may and the shall, that you are vesting in the power of the court to exercise power in relation to people's property. And we don't think, right, that we, as the people, we here, speaking on behalf of the people of Trinidad and Tobago, deserve better than this? Really? That's why, right? That's why I sat down for the last 48 hours to sit down day and night to draft 60 more amendments. The lower house only dealt with Division 1, 2, and 5. This morning, last 2 days, I was dealing with 3, so that have 60. When I finish speak, I'll deal with 4, which might have another 60 more, right? But I'm sure that somebody will get up early tomorrow and go on the TV and talk about who's responsible for which amendment. The people of Trinidad and Tobago deserve better than this. They deserve better than this. Because you know why? Because you're interfering with their property rights. There are 2 sections in this legislation that allow the powers that are given under this legislation to go back in time. Senator Mark said it goes back to slavery and indentureship. Reference was made by the Attorney General of the fact that he files an integrity in public life form, just like all of us here. Nobody doesn't see anything wrong, or nobody doesn't see anything jump out at them by the fact that everybody who is sitting in this Senate files an integrity in public life form that says you must disclose your assets 1 year before and 1 year after. So that might be too proportionate, because we are told if you could go back to slavery, that's proportionate. So the drafters of the integrity in public life that said you could go back 1 year before you enter office, and when you leave office, you must declare for 1 year after. That is over proportionate. That's not proportionate, that's over proportionate. You see, Madam President, the next thing is this. While I was going through this with a fine-tooth comb, I remembered that the government said all of these things must be on suspicion, because that is the basis upon which the proceeds of crime operates. Everything in the proceeds of crime, all the amendments that the opposition brought with respect to reasonable belief, the answer to it was that, don't worry about that. In the proceeds of crime, everything is on suspicion, so we will go on suspicion in this. But I don't know how I pick it up. At page 35, section 38(4), they give the police the power to go in your house. To go in your house, not only a business place, to go in your house. Hear what it says. If during the course of a search, under an order granted under subsection 2B, a police officer finds any property that he believes on reasonable grounds is of a kind that could be included in the order, has its existence or its existence at that place be known of at the time of the application for the order, he may seize the recoverable property, and the seizure order shall be deemed to authorize the seizure provided. So, how come it is when they want to take your property at the very beginning, everything is on suspicion? When they come into your place, right, it all goes down to reasonable belief. So, what is the difference in the standard, Madam President? What is the difference in the standard? Both of them apply. Both of them give the power to do what they are seeking to do. But in one, you tell us, proceeds of crime, we're going under suspicion. But down in 38(4), you're on reasonable belief. Here it gets better. 38(5), property seized under an order granted under subsection 2B. So this is where you go for the court order, you go in my house, you take up my property, right? May be retained by or on behalf of the agency for 28 days, and the agency may subsequently make an application for a property restriction order in respect of the recoverable property. So after the 28 days finish, what happens to the property? They have no obligation to return it to the person. When you don't make the application, it just remains there. Well, perhaps that is what the government foresees to be the position. Now, Madam President, it is very clear to me that this legislation, in the form that it provides, it is presented to the Parliament.
Senator Ramdeen, you have 5 more
Thank you,
minutes.
Madam President. It is very clear to me that this legislation, in the form that is presented to the Parliament, is a good PR stunt for the government. That's exactly what it is. It is a good PR stunt for the government to tell the country that they fight in crime, you must explain your wealth. But I want to join Senator Mark, and I want to tell the government that when this legislation is implemented, the first people, right, that should be explaining their wealth is the people in the government. Start. You know why? Lead by example. You know they always say must lead by example? Lead by example. And let's see how far we will get with going back. Because I couldn't agree more with the member, the honourable member, the honourable Minister of Public Utilities. I want to agree full 100%, as they say, with the member for Public Utilities. The Minister of Public Utilities, Honourable Minister for Public Utilities. You know why, Madam President? It's really about time that the people who for years have gotten the jump start on the hard-working citizens of this country are made to account to the people of this country. They have gotten a jump start for years. It doesn't know 100 meters. It's maybe 100 years they got a jump start for. And today, the hard-working people, you want to tell people in this country that if your wealth is over $500,000, you must explain your wealth? What about if it's over 500 million?
Exactly.
What about if it's over 500 million in one generation? We turn in one generation from indentureship and slavery to get an education to become lawyers and doctors. But it have people who in this country, in one generation, they turn from selling cloth to being they almost own the entire country. And you want to tell us about explaining your wealth?
Your presentation is taking a turn that is just, please, just watch it, please. No, don't talk to anybody else but to me, okay? Continue, Senator.
Did the Attorney General withdraw that? He said I was engaging in racism.
And hatred. He said racism and hatred.
You didn't hear that?
Please, Senator Obika, I wish members of this chamber would leave the running of the chamber to me, okay? Attorney General, if it is that you said that, please withdraw it.
I did say it, and I withdraw it.
Senator Ramdeen, and please heed what I have told you about your contribution.
Yes, Madam President. We on this side will continue to stand for the majority of the population of Trinidad and Tobago. We will continue to stand for the people who have toiled hard to educate their children and to have a home and a livelihood built on hard work and industry. They are the people that built this country, and we will stand. You will get our support, but the day you seek to use this legislation to persecute any citizen of this country who has worked hard and toiled, and you want them to explain your wealth for over 5 years, you will answer, just like this morning in the Court of Appeal, you will answer in the court of law, and we will stand with the population of Trinidad and Tobago. I thank you, Madam President.
Senator Seepersad.
Thank you, Madam President, for the opportunity to contribute to the debate on the establishment of the Civil Asset Recovery and Management Agency Bill 2019. Madam President, we recognize and accept that Trinidad and Tobago's geographic location, generally stable economy, and developed financial systems make it vulnerable to varied illicit financial transactions, including money laundering. The drug trade and related underground economy accrue unexplained wealth to both Mr. Big and Mr. Small in varying degrees. Wealth which does not fall within the net of the BIR, but is acutely visible to anyone who chooses to look. Madam President, this law will make it difficult for the so-called community leader, gang leader, or drug lord who are predisposed to ostentation as evidenced by their lifestyle and possessions such as gold chains, cars, expensive jewelry, properties, multiple households, etc., to legally account for their wealth. However, the white-collar criminals with legitimate business fronts can conceal their unexplained assets and have the resources and the expertise to find safe haven for their ill-gotten assets. Madam President, we have made significant inroads in addressing the AML, CFT deficiencies, yet more is required to achieve compliance with the requirements of the international financial systems. Continued legislative and institutional reforms alone cannot achieve this objective. It is imperative that adequate resources are provided for full implementation, and a monitoring loop is required to ensure that the enforcement of Trinidad and Tobago's AML regimen is assured. It is imperative that the investigative capability of the police and other security services, customs, etc., be significantly strengthened to include the multitude of disciplines required to fight against this category of criminals. Madam President, I'm also concerned that the security, integrity, and confidentiality of information obtained from persons under investigation can be compromised. Further, Madam President, as pointed out by Senator Vera, this legislation requires the citizenry to keep complete and accurate records of their financial transactions to be able to account for their wealth. There is need for a robust education campaign to inform and educate citizens on the requirements and obligations of this legislation. In closing, Madam President, all leaders in this country must show real commitment in the fight to eradicate these crimes, to ensure law and order is returned to Trinidad and Tobago. Thank you, Madam President.
Senator Thompson-Ahye.
Thank you, Madam President. I must admit to standing here quite conflicted. On the one hand, part of me says, hope springs eternal in the human breast. This is Holy Week. This is the season of hope. So we really should have hope. But on the other hand, something says to me, plus qu'un change, plus c'est la même chose. The more things change, the more they remain the same. Which is it to be? Perhaps I can begin by tidying up some of the provisions. May seem pedestrian, but we just had students go through a rigorous common entrance exam, and which I dare say some of us wouldn't be able to pass. So let's start with clause 3, and I want to make some suggestions before I go into some nitty-gritty. The interpretation section, clause 3, criminal conduct. B, and my suggestion is criminal conduct means conduct which constitutes a specified offense, or if it occurs in a country outside of Trinidad and Tobago, would constitute an offense in that country. And I would take off part 2, if committed in Trinidad and Tobago, would constitute a specified offense, and put would constitute a specified offense in Trinidad and Tobago. I think it makes for simpler reading. We come now to the definition of reasonable living expenses. Madam President, when I look at, on page 5, the definition, reasonable living expenses includes, and I know that lawyers would always say includes means not limited to. But I'm surprised that under the definition of reasonable living expenses, an Attorney General who is noted for his sartorial elegance would not have included in living expenses things that are normally included, such as basic clothes. So I would like to see that in there, because if one looks at other civil legislation talking about reasonable living expenses, matters like clothes and transportation are included. So I would like to see that put in there for greater certainty. I don't think that the Attorney General was old enough to have seen the Gina Lollobrigida movie in 1961, where she gave have a certain name, but I won't go into that there. Now, indeed, in that same reasonable living expenses, I would advise that the word dependent, spelled with an E, be spelled with an A, the noun, and not the adjective. In clause 5, my suggestion is that instead of putting the standard of proof shall be that applicable in civil proceedings, that we actually state it that it shall be proof on a balance of probabilities, as we have it in clause 45 and clause 50. In clause 9, the agency shall comprise. I would suggest that we take off the of after comprise. Clause 58, unexplained wealth. This is a very, very important provision in the legislation. And I wonder, though, who is to do the forensic examination so we can determine what is unexplained wealth. And before we come to the stage of unexplained wealth and the determination of that, there must be an investigation for a specified offense. And when we look at specified offense, we have to go to the proceeds of crime. And many times during the course of the interpretation section, we are referred to another piece of legislation. And I find it sometimes a bit annoying that I want to find out what is terrorism. I have to go to the Terrorism Act. I have to go to this act. I have to go to this act. I know it makes it much shorter, but it is much more convenient for a non-lawyer to have it spelled out. So you want the legislation to be perhaps a bit tighter, but it makes it much better for someone picking up a piece of legislation to be able to read it through in its entirety, rather than have to go to this act and go to another act. So you have to go to the Proceeds of Crime Act, you have to go to the Terrorism Act, you have to go all over the place to find out exactly what each word means. So perhaps that is a consideration that the drafters don't like, but I certainly recommend it. It's easier for me, I'm sure, for other people as well. Now, we first have to have an investigation of a specified offense, and we have quite a few, 21 of them, listed under the Proceeds of Crime Act. So we want to determine the wealth of the person, and you have to investigate. Now, I have heard the Minister of Public Utilities, and I've heard the Attorney General, and I've heard a number of people talk very highly about the legislation. The word, it sends a strong message that this government is serious. We have the political fortitude. But you know, we always want to be real. And before, as I said before we come to this, the other part of the legislation, we have to ask ourselves, is there really going to be an investigation of these crimes, except insofar as they deal with the small man? Is it that we are going to now have a new society, a society that offers us the promise that everyone is equal under the law? And we will not have a society where young men are not picked up for marijuana in Westmoreland and Goodwood Park, but are picked up in other parts of the society because they are more vulnerable. Is it that we are going to have a law here that we are going to use to really get at those people? Because all the time, Mr. Manning used to talk about Mr. Big. We know who is Mr. Big. And Mr. Manning has gone to his grave, and Mr. Big still has not been apprehended. So is it that today we are going to be in a society where we have the Mr. Bigs, because it's not just one, going to be actually apprehended and have his, his wealth taken away from him, and all of these people going to get into the play, the trustees and the managers and all of these things, to return some kind of equity to the society. And that is the dawn we want. We want the dawn of a new day. And the minister spoke about we have nothing to fear, the Minister of Public Utilities. We have nothing to fear the ordinary person. We have nothing there's not fear he used, no. He said that it would not affect the ordinary person, but it should. It should affect the ordinary person. The ordinary person who is affected by the structural violence of the society, who cannot get the utilities, who cannot get all of the things that they are required to have, which they are entitled to because we don't have the money. If it is that we can bring back the money, then they should be affected in a positive way to make sure that they can have a better life, that they don't feel this sense of hopelessness, that they can live a life like everybody else who has money. Because the government now has the money, having confiscated the riches from those people who their ill-gotten gains, that they can now use that money, Madam President, to make a better life for the society, to offer hope for those who are without hope. And there are many who are without hope in the society. So this is a bill that offers a lot of promise. But will that promise be kept? That is the question. Will that promise be kept? Because we have to understand that it's not just a big man. We have a middleman. We have a middleman. And the big man does not keep in touch with the little man. So we have crimes going on here. We have trafficking in human beings. We have sexual exploitation and so on. And we know that very often those who are apprehended are those who are at the very bottom, those who are involved in street crime. But those who are at the top, who actually engineer and facilitate the commission of the crime, those who are below cannot even call them and say, I have been arrested, because the word is, don't call me. Don't call me. You get your part of it, and if anybody holds you, don't call my name. You dare not mention my name. So that whole ladder, that going from the top to the bottom, we want a law that is going to touch every one of them at every level, not just the small man, the middle, going right up to the top. We want a law that is real. We want a law that is not just talk, is not just paper, but a law that is going to work and going to make ultimately a better society. And that is my prayer in this Holy Week, in this season of Easter, that it will be a real law that will benefit the entire society, a new dawn. I thank you.
Senator Haynes.
Thank you, Madam President, for the opportunity to come to participate in this very important debate. I'd like to start by just giving some context very early on. There's been quite a significant amount of conversation on this debate, both in this Parliament and outside. And it is because, despite its rather intimidating title, the citizens are asking, what does this mean for me? And the government is seeking to say to citizens, you don't have anything to be worried about. But the importance of this debate really cannot be understated. What we are seeking to do is say to the country, this is our problem, and the government is presenting this as a solution. And I want to, like I said, give some context. This bill is brought before us with a simple majority to pass the legislation. And so to the listening public, this means that the government has made a decision that the provisions in this bill, they are willing to pass it on their own merit and not include all of our voices. The opposition has stated, once the legislation is good, once we've made relevant amendments, we are willing to support the legislation. But some may say, if we are willing to support the legislation, then what is the need for all this long talk? Why is everybody speaking? What is the importance? And I'm starting there because the Attorney General, Senator Simonet, Senator Vieira, all noted and called this legislation nuclear, right? And I thought that was an interesting terminology, and it's very important because you know what is one of the core tenets, one thing that you understand from nuclear activity or a nuclear bomb? And I'll give a little history here. In World War II, when the first nuclear bomb dropped on Hiroshima, that first bomb was called Little Boy, a term that the Attorney General is familiar with. Mm-hmm. When Little Boy exploded, it exploded with 13 kilotons of force, leveling 5 square miles of the city. 80,000 people died instantly. Tens of thousands of persons would die later from radiation exposure. So when we describe something as nuclear, Madam President, it's when you drop that bomb, like we are trying to drop this bomb with the civil asset forfeiture, we have no control when it leaves our legislature. So all you're talking about is targeted approach, and we're targeting these people. We have no control. By your very definition, from your own description of the legislation, we are dropping a bomb on society, and it is therefore our responsibility as a legislator to take our time, to be very careful, to be very deliberate, to air all the views, Madam President. So it is my respectful view that we should all be speaking in on this debate, and we should all weigh in because of its nuclear nature. And I go quickly, Madam President, to how this bill was rolled out, because in some of the comments that I've been privy to, a number of persons have approached me and said, well, why are you all rushing this if it's so important? And the bill was read in the House of Representatives for the first time on March 22nd, 2019, and then debated on April 5th, 2019. Then the bill was read here on April 11th, 2019, and now we're debating the bill. That is 25 days, Madam President. And given the nuclear nature as described by the mover of the bill, I would say that you would have wanted to give sufficient time for a public discourse so that you could digest the debate in the House of Representatives, get a sense of what the population actually wants, what people are saying. Again, this goes back to a consultation point of view, because as you're saying, it is nuclear. That is their description of the bill. And therefore, we ought to be, like I said before, very deliberate and very careful. Now, Madam President, the Minister of Public Utilities has invited us to think about the kind of society we would like to see. And in his presentation, he listed a number of things. But that stood out to me, for us to think about the kind of society we would like to see. Because this particular bill gives us, as a society, enough space to think about what it means to increase the state's power and the state's authority, and that with respect to the individual's rights and freedoms. And that is a central tenet of this debate. And I went to John Stuart Mills, who in one of his thinkings on liberty and authority, spoke of the need to protect who will guard against the guards, right? And on liberty, John Stuart Mills used some very colorful language to describe a government who would use its power to increase executive power or state power at the expense of ordinary people. And he referred to any government, really, as vultures who existed on the backs of citizens. This is a long time in coming. And this kind of debate and this kind of political discourse has existed over time. And it's a constant struggle, because you would have a state saying, we are existing under these particular circumstances, and I'll get to that shortly. And based on these circumstances, we have to pass these laws. And these laws will help us to protect you, and it will help us to serve your interests better. But as a citizen, it is your responsibility now to take a step back and say, does the government need this extra power? Does the state, and when I say the government, I mean the state and agencies of the state. So I don't want anybody to think I'm speaking directly about the executive here, but agencies of the state as well. And are you saying to us that this increase in government power would have an effect for the citizens that would make our lives better, to improve our standard of living? And as I was thinking through that, I remembered early on in the tenure of this government, there was a raging debate over the SSA amendment bill. They said, we need to pass this. This will keep you safe. And in that bill, you had the conversation again about the liberties of the people, the rights of the individual, versus the increasing power of the state. Same conversation, Again, the government said, listen, we need this. Give this to us, and we will protect you. That was 2016. Between 2016, 2017, 2018, we have seen an increase in crime. And so when you come now to tell us, give us this new thing, this is how we will protect you. Madam President, I, for one, think that citizens, and all of us, should now pause for concern, because this use of fear of crime and criminality, and that we are all afraid of what would happen if we allow crime to continue unabated, and then this constant approach by the government to use legislative aims at curbing crime, I would say that has already failed. So you ought to think now about where are your policy positions and your policy directives as opposed to your legislative interjections, because you've done that already. So, Madam President, I started by looking at the context of the debate in terms of what it means for state authority versus that of the citizens. And Senator Ramdeen quoted from the Institute for Liberal Studies, so the Canadian Constitutional Foundation. And where I thought this was important, Senator Ramdeen went to the section on the grading of the different provinces. But this document went further to examine issue by issue the problems associated with this legislation as enacted in Canada. And what I took from that, Madam President, is as a responsible nation, we can look to where this legislation has been enacted and have a very responsible and well-reasoned discourse in terms of what happens when the legislation is in play, what happens when you drop the nuclear bomb. And these people, Madam President, they looked through a number of issues that were already discussed. But I want to go to one of the problems that they raised, which is on transparency and accountability. And the document, and I quote here, says, no province has surveyed whether its forfeiture regime is meeting the statutory goals of deterring illegal acts and compensating victims. Instead of conducting such an evaluation in an open and transparent fashion, it is common for civil forfeiture officers to point to assets seized and funds distributed as evidence of successes. And of course, this is a completely unsatisfactory reasons discussed above. Now, when I looked, Madam President, at the legislation under Part 3, financial provisions, and it spoke about the Civil Asset Recovery and Management Fund. And there's also a debate raging in the United States about once you've seized the assets, this system, so this is Clause 21, Part C says any money derived from the disposal of and dealing with real or personal property will be held and owned by the agency. And so internationally, there's this discussion that I think is important for us to think about here. When we think, because we have a system in Trinidad and Tobago where we'll do things and we do not effectively monitor and evaluate whether the things that we are doing are working. So we would have done something and we cannot say with any data or any evidence whether or not that thing is working. It's all conjecture. So this idea that you seize assets and you dispose of it and then it goes back into the agency. You saw, and there's a discussion in the United States, in Canada, about whether or not this works, or does it incentivize the seizure, incentivize these agencies to go out there and seize property without thinking about what the legislative aim was. So are we passing legislation, not looking at what real-life examples globally have said to us, and saying, okay, let us think about how we can fit this into our society in the best possible way. And as I'm speaking about how we fit this into our society, I have a document here it's comments from the Citizens Watch Group on the legislation. Now, like I said before, this piece of legislation has generated a lot of public interest, which I think is very good for our democracy. We ought to be talking about our legislation and thinking about it and have citizens participate. The CWG's concerns listed a number of things that we've already discussed here, including the constitutional protection of property rights and the deprivation of such property only by due process of law. These are their concerns. The need to ensure that ensure such due process is moving against property. Particular issues in terms of the standard of proof to be used, the general need for the protection of constitutional guaranteed rights of citizens, the link between the proceeds of crime and the persecution of perpetrators of serious crime. In particular, the troubling to them is the provision for the forfeiture in the absence of a criminal conviction or even a criminal charge or prosecution. This idea of suspicion, Madam President, and the possibilities or opportunities for abuse and or manipulation of such measures. The danger of abuse affecting persons not engaged in crime or particularly organized or serious crime or corruption. The authority to initiate such mechanisms and the use to which the seized assets and the seized asset funds are going to be put. So this was some of the comments, and I'll go back to this document. But, Madam President, all of these concerns are legitimate concerns that ought to be properly ventilated and properly discussed. And in our research, going to the International Journal of Evidence and Proof, on an article from October 1st, 2012. So again, this has been in public discourse for a long time by Colin King. This is the Center for the Criminal Justice Studies, School of Law, University of Leeds. And this is an examination of, one, how this legislation was put in place in Ireland. And more importantly, I think, Madam President, because the answer that would come from the government bench to a lot of these concerns would be that, well, you always can seek remedies in the courts. And I raise that because this particular article, and I'm going to quote a little bit from the abstract here, says that, going through the distinctions between criminal and civil, that the Irish judiciary has responded to this approach, looking at the difference between civil and criminal, ultimately contending, the article contends that the courts have failed to provide a check against the legislature, circumventing enhanced procedural protections of criminal processes and imposing punishment in the civil forum. Now, I won't go through all of it, but I will invite interested persons to go through and look into this article, because it really goes through why it is important for issues to be properly ventilated in the legislature so that you can get a clear intent of what the Parliament intended to do and what we intended to do here. So we must be very clear on that. But it also helps us understand that when you tell us that the courts will be our remedy, the courts will be our savior, you also have to understand that they would be looking into it to see what was our intention. And there are examples, Madam President, where the courts, and this is one, have deferred to what was the intent of the legislature rather than saying, you know, you've overstepped your bounds. And I think, Madam President, that is in a large part why the opposition bench is insisting on a 3/5 majority for this piece of legislation, so that you can say for sure this is what the Parliament intended. Now, Madam President, the article looks at non-conviction based asset forfeiture, due process, and punitive civil sanctions. So you're looking at non-conviction based asset forfeiture, which is what we're talking about, that you do not have to be convicted of a crime, raises serious concerns about circumventing traditional due process protections that are inherent to the criminal process. Now, this goes to what Minister Hunte was saying, which is this idea that if you are innocent, you have nothing to be worried about. But the very nature of this allows for you not to be convicted of anything. So therefore, you are innocent. And therefore, you do have something to worry about. So I find that rhetoric to be disingenuous. So what you're saying is, under this legislation, that you didn't meet the threshold for liability under the criminal courts. So we had to do this. This will solve our problem. But by that very nature, Madam President, these are still people who are innocent until they are proven guilty. But we're saying that you didn't meet the evidence threshold. So to come here and tell us that you don't have anything to worry about, that once you can prove your innocence, And that is a very slippery slope to step on. From the time you start going to citizens and saying, listen, they are the guilty ones. The guilty ones, you'll see them, they'll start to react negatively to this, and they would be the ones who will not support this. You see, that puts us in a tricky position. Because if you're just a person who supports the rule of law, who supports democratic principles, who supports a smaller government or smaller state with less of Big Brother watching you, basically, if you are that person, then automatically, by that rhetoric, you are deemed to be suspicious. By your having negative sentiments to this bill, the government was trying to tell the population that you should deem anybody that may not want this bill to be suspicious. And that is the slippery slope that I am talking about, Madam President. It is not suspicious, in my belief, to say, hold up a minute. I understand that crime is a problem. I understand the emotions behind it. And I listened to the Attorney General in the other place. And he was very emotive, going to the heart of, if you know, this idea of this social situation where people are benefiting from the proceeds of crime. And yes, all that may be well and good. But then how do you legislate? Do you legislate based on our emotions because I am vexed that this thing is happening and therefore I'll pass any law to stop this problem? It cannot be that, Madam President. We have to set standards for ourselves. And in my initial reading of this legislation and some of the commentary behind it was that powers that be as it stands now feel that where the standard is set, they cannot achieve the aims and objectives. So rather than raise the bar of their operations to meet that standard, they said, here's what we'll do. We'll lower the bar and therefore meet that lower standard. And I don't know that that is the society that I want, as Minister Hunt had asked me to think about the type of society that I would like to see. You see, Madam President, if we keep lowering the passing grade and saying, crime is a problem, let me remove this check. Crime is a problem, let me remove this check. Crime is a problem, let me... And you enable, and then you whip a population into a frenzy, and you put to the legislator that, look, the country needs this. This is the only way to stop crime. This is the only way to save our nation. We will have a problem. Like I said, a very, very slippery slope. These checks, these procedural safeguards in a criminal process, those things are important to any democracy. Those things are important to a functioning society. So to say, and to appeal to our emotions, and to appeal to our country's emotion, to increase state power because we are afraid, Madam President, is something that I really cannot stand behind. I think whenever we approach the process of lawmaking, we should do so with reason, with evidence, with the fact that you can come here and tell me, let us look at all these different jurisdictions. The legislation has been working, and it has been working well. It has been evaluated. We have done this much work, and then we're bringing it here. Don't bring it 24 days. Say, look, pass this thing, and then have Senator Ramdeen come here and go through this Canadian model showing that it has failed in several provinces, because we aren't then going to do anything that is effective or important. And I noted very early on where the government had intended to take this debate and this public conversation. Because once the legislation was laid in the Parliament, you had persons on their side making the rounds on the news, wherever, stating, I think one person used a very inventive, you wouldn't see turkeys voting for Thanksgiving or something to that effect. Right, Madam President? And so you're saying all these things outside, trying to whip, and then, coming in here.
Senator Haynes, I have given you quite some time to put your presentation in context. You have done so, but you are belaboring certain points, and I will ask you to be a little more specific as you proceed.
No problem, Madam President. I'm speaking here now on the unexplained wealth section of the legislation. And the reason that I am raising what the what the conversation was publicly, because a number of persons, including that document, Citizens Watch Group that I said, raised this idea of, can this legislation be used for political persecution, etc. And I wanted to contextualize why, one, I took a very somber approach to this legislation, because I wanted to go out, be absent of any sensationalism and any of these things, and just go to what the studies were telling us and the data was telling us. But you cannot absent yourself from the political discourse and where this thing was going. So you hear, Madam President, about persons having to explain their wealth, and if you aren't, then those are the persons that ought to be afraid. And I'm saying part of that, this unexplained wealth, is where you have, I think, a government being very irresponsible in creating a national discourse that will put us on the slippery slope that I spoke of earlier. And this idea that there are persons in the legislature who will not want to support this bill because they are the ones who are afraid. Madam President, that is dangerous language, right? Those kinds of things, when you put it out into the public domain, it lends a sense of saying, we come in to catch everybody, right? So we're creating this law, and we're going to catch you, and we're going to catch you, and that will solve the problem. It really takes away from the seriousness of the legislation and the seriousness of what we do here, Madam President. And the reason I raised the turkeys voting for Thanksgiving, but it's because that in and of itself showed, saying to people, only those who are guilty, you have to worry about it. And I mean, it's just simply not true. Madam President, it is still the view of the opposition that any civil asset forfeiture in the absence of a conviction is draconian, and it is a very draconian measure. And they may not be using the same words, but by calling it nuclear, you have admitted that. So therefore, if you know that the legislation is nuclear or draconian, then perhaps put it to a 3/5 majority. Madam President, we have also seen that, and I told you I was going back to the point of using fear to promote legislation. And I have here a research article entitled Fear, the Foundation of Every Government's Power by Robert Higgs. And I'm going to go to the idea of the political economy of fear. And fear, like every other productive resource, the article notes, is subject to the laws of production. Thus, it cannot escape the law of diminishing marginal productivity. As successive doses of fear-mongering are added to the government's production process, the incremental public clamor for government protection declines.
Madam President, 46-1, please. This is not a lecture in political science.
Senator Haynes. Yes. Very interesting, what you are reading from. What I'm going to try and ask, what I'm asking you to do is you need to talk through. You're reading a lot, you're quoting a lot, but you're not applying it to the debate. And I need you to be a little more precise, okay?
No problem, Madam President. And I'll show you the relevance now. There's no problem with that. The reason I raise this political economy of fear, Madam President, because this is within my concluding remarks, the Minister Hunte said that, you have to look at this will stop the money laundering and will stop all of these things. And that again, whip up this country into the state of fear. You've seen it with the FATCA legislation, you've seen it with the anti-gang legislation, etc. And I raise that to sound a warning to the government, that if you keep doing that, that's just academic language for the boy who cried wolf. You keep telling us these pieces of legislation that you are bringing will ease our pain and ease our suffering, and you keep frightening us and frightening the population, and you keep not delivering. You have consistently not delivered on your promises, and our murder rate as it stands shows that, Madam President. So I raise that, as I concluded, to say that this legislation while you tell us and you raise all of its lofty standings and whatnot, at the end of the day, it opens a political conversation for us to look at how the state increases its power, and you cannot continue to frighten us into giving you more and more power. I thank you. Pardon?
Minister of Agriculture, Land and Fisheries.
Madam President, I thank you for the opportunity to speak on this bill. Let me from the outset say, Madam President, that this is my biggest fear about this bill, that we in the Parliament become so focused on each other and the 72 legislators sitting in both houses, that we forget, Madam President, that there are thousands of police officers, hundreds of customs officers, hundreds of persons involved in procurement in the public sector. I heard a figure of 200 or something gangs, with gang leaders, gang members, and so on. And surely this will apply to politicians. But to me, when I first encountered civil asset forfeiture legislation, throughout, right up to now, my mind has been on those persons who, without justification, have accumulated the trappings of wealth for which they should be made answerable. And as you drive through the country, Madam President, starting with where I grew up, the place where marijuana, for example, flourished, and we saw massive houses rise out of the ground. And I'm talking about 30, 40 years ago. This legislation is too late. And what we're trying to do here is to make up for lost time. I support this bill because it gives us, like it has given a number of territories, the opportunity to do something in addition to what the criminal law is capable of doing. Madam President, I listened to Senator Ramdeen and then Senator Haynes specifically. I listened to all the senators on this issue of the Canadian use of this legislation and the criticism of one organization.
That's not the model.
But let me put it in context. There are many constitutional organizations in Canada, many of them registered charities. And this is one, and I have no interest in examining or condemning their report, except to say that the last executive director of the Canadian Constitution Foundation is the former Deputy Chief of Staff to Stephen Harper, the former Prime Minister of Canada. So it is not completely independent. If you know anything about the history of Canadian politics and the approach across provinces to the Constitution, you would know that Alberta has been one of the strongest defenders of the Constitution in its purest form. And any opposition to anything that looks too liberal normally comes from an organization that resides in Alberta, as does this Canadian Constitution Foundation. And it is no accident that Mr. Harper, who himself came from Alberta, would have a Deputy Chief of Staff who will eventually go on to be Executive Director of this foundation. As we say in Trinidad and Tobago, take it with a pinch of salt. Madam President, the other thing I would say is this. I've heard references to the Canadian approach to civil asset recovery, or forfeiture as we call it. And I want to make this point. Nobody has pointed to the case of Chatterjee versus the Attorney General of Ontario. But once the civil asset forfeiture regime came in Canada through different provinces, but specifically in Ontario and British Columbia, it has been the subject of various challenges as we would expect. And this piece of legislation has made its way to the Supreme Court of Canada, and it has been found to be constitutional. And I would say this in relation to the report cited and in the context of this type of legislation. The reason why that report would have given several pieces of provincial legislation an F grade is because the foundation has maintained one argument in the main, and that is the foundation has said consistently that assets should be forfeited after a criminal conviction. And we know well, Madam President, that our law, it does in fact provide for the forfeiture and sale of assets post-conviction. We also know that this piece of legislation sets out to do something that is very clear, to allow for the recovery and disposition of assets without a criminal conviction. So that to anchor any argument in that report, that organization, would be to miss the point of the criticism that across Canada there have been a number of advocates who believe that any forfeiture should be post-criminal conviction. And I would say the second point in relation to the legislation, Madam President, we have to be very careful in approaching the Canadian law. Canada has the three systems of government, the federal, provincial, and municipal. And you must pay close attention to the fact that criminal law, as we have in our separation between ourselves and Tobago, criminal law is reserved for the federal government. So the argument in relation to this type of legislation has been an argument as to whether this law, this type of civil asset forfeiture law, interferes with the federal power in relation to criminal law. And those who argued against this type of legislation, they've rooted their argument on the unconstitutionality of it simply because they've said this essentially is criminal law and it offends the separation between the provinces and the federal government. And in Chatterjee, and if I just, for the record, Madam President, just to say that in the case of Robin Chatterjee versus the Attorney General of Ontario, in its decision delivered on November 12, 2009, the Supreme Court of Canada, on appeal from the Court of Appeal from Ontario, ruled that this legislation, this type of legislation, was constitutional. And I want to say, Madam President, that I've not heard a lot about the objects of this type of legislation. But if we go to that particular case, we would find language that I think as a society we should be happy to associate with. And the general view, this type of legislation has three specific purposes. One is to make crime in general unprofitable. Two, to capture resources tainted by crime so as to make them unavailable to fund future crime. And three, to help compensate private individuals and public institutions for the costs of past crime. And Madam President, I just want to quote from this particular decision of the court in terms of what we're trying to do as a parliament. And in this judgment, I'll just quote this paragraph. It says, "It would be out of step with modern realities to conclude that a province must shoulder the cost to the community of criminal behavior, but cannot take legislative steps to suppress it." Madam President, some years ago when I was writing for the Express, I wrote about the criminal justice system, and I used an expression called the keel of crime. And if you understand the architecture of a boat or a ship, the keel is the most important part of the structure upon which everything rests. And the point I was making there is that the financial system in Trinidad and Tobago is the structure upon which crime is built. Whether we talk about money laundering, whether we talk about using funds to acquire assets, whatever we do, the financial system and this money that flows through our system represents the place upon which crime is built. And if we have to tackle crime, it is not just the incarceration of individuals, it is not just the no bail, it is not just the vehicles and the guns and so on, but Madam President, we must tackle the money. And part of the money must involve the assets which are accumulated. Because, Madam President, when we look at the objective of the legislation, it is not the accumulation of the asset alone that we are dealing with. It is the ability of the asset to continue to fund criminal conduct. And we don't have to go very far again. We don't have to go far to understand, and I'm using the Canadian example because my friends have used the Canadian example. But I use one example in terms of criminal activity in Canada. Canada has for a long time tried to deal with the Hells Angels. And the attempts, whether it is on that side of the border or the other side of the border, the attempts to prosecute the Hells Angels in criminal prosecution has proven to be very difficult, mainly because, Madam President, not many people are willing to come forward to give evidence. Not many members are willing to be the source of information and evidence. And the criminal justice system has used different ways to extract that information, including planting police officers in the organization. And prosecution has proven to be difficult. But right now, Madam President, in the same British Columbia of which my friends have spoken, there are proceedings which are going on right now to seize the asset and dispose of the assets of the Hells Angels, the physical assets. And again, in the context of that particular organization, they are the owners of what is described as clubhouses around Canada, in all the provinces. And the effort is being made by the equivalent of the agency which we are attempting to set up here, to seize those assets and dispose of those assets, not only because of the connection of the assets to criminal activity, but more importantly, the potential of the assets to continue to fund and allow criminal activity to flourish. Madam President, I want to say a few things which we cannot argue with. And I listened to my friends very carefully. I listened to hear whether anybody had a problem with the issue of forfeiture. And I heard nobody say, well, I have a problem with taking somebody's assets. Because forfeiture has existed in the law for a long time. Bail provision in poker and all the predecessors, state and so on. We understand the concept of forfeiture. So I don't believe that anybody has a problem with taking somebody's asset. I've listened to see or listened to hear if anybody had a problem with the disposition of assets, the sale of assets, a power that has existed for a long time in both criminal law and civil law. The most important place on the civil side is the mortgagee's power for sale, which is at the heart of lending and putting up assets for lending and being able to recover in the time of a default. So, Madam President, I have heard no one with a problem on the issue of being able to sell an asset. The issue of disclosure, I've heard nobody talk about. I don't like the fact that you have to provide information. Nobody should be called upon to provide information, because in this bill, the bill works because you are in a position where you can call upon somebody to provide information. The unexplained wealth order is driven by that. The power to compel somebody to provide information, and I have heard nobody say that the citizens of this country should not be called upon to provide information or make disclosures. And those powers already exist, but in a very circumscribed manner. For example, in POCA and in the Integrity in Public Life Act, there are certain circumstances in which you are called upon to provide disclosure and provide information. But on that point on that area, it is there we start to understand the far-reaching consequences of the legislation, that this applies to everybody. This applies to everybody in the context of an investigation into an offense under POCA. It applies to everybody, and everybody is at risk. There's no special group that is at risk. Madam President, I have not heard, even though it is an important part of the debate, I have not heard sharp differences on the issue that this really is treading on criminal matters, because that has been part of the conflict, as I've said before, even in Canada. That has been part of the conflict, that you are really producing a type of criminal law legislation masked as civil law. And you're doing that because you do not wish to go through the existing criminal justice processes. But there's been no, unless it's still to come, sharp differences on the fact that this works alongside the criminal justice process. It works alongside, and from a practical point of view, Madam President, partially due to the length of time our prosecutions take, the resources that are required and the complexity and so on, but the length of time and the fact that while we pursue trials as we are entitled to do, the criminal organizations flourish. And Madam President, they flourish to continue to fund their defense in some case of the criminal matters. And if we have to slow criminals down, or if we have to slow the pattern of criminal conduct down, we have to find the tools to do that. And that is why I've referred to those two lines from the case of Robin Chatterjee versus the Attorney General of Ontario, to say that if, as a society, we have to confront criminal conduct in our communities, if we have to deal with it, then as a legislator and as legislators, we have to be prepared to pass the appropriate law. And if, Madam President, like Chatterjee, somebody in this country believes that their constitutional rights are being interfered with, that the legislation offends, the legislation is too broad, the legislation overreaches, then our system provides for someone to challenge that legislation. But we are following on the heels of other legislators around the world, we are taking a legitimate step, as we are allowed to use our ability to create law without interfering with what happens in the criminal justice system. And I've heard no argument so far. I've heard no argument which tells me that what we set out to do today is illegitimate in the sense that we are interfering with or taking on a power that we do not possess as a legislator. And, Madam President, the most debate should arise on the issue of the rationale for this bill and the risk that is contained. Because I would tell you, in the wrong hands, this is dangerous legislation. In the wrong hands and improperly crafted, this is dangerous legislation. And it is legitimate for anybody in this House to stand up and argue on the issue of the risk inherent in legislation of this nature. And if you do that, then I would invite you to go through the bill and see within the bill all the checks and balances and so on, the thresholds which must be achieved in order to bring action, interfere with assets, dispose of assets, or to do the things that the bill provides for the agency to do.
Honourable Senators, at this juncture, we will suspend the sitting and we will return at 5:30 p.m. Minister, you have utilized 21 minutes of your speaking time. We're suspended until 5:30 p.m.